Judge Caldwell had finally had enough. No raised voice, no theatrics, no warning shot, just 4 words that froze the room. Marshals, remove him. Now! Before the sentence even finished leaving his mouth, 2 armed federal officers were already moving. No hesitation, no glance for confirmation. This was not a suggestion. This was an order. And everyone in that courtroom knew it. What happened next is the part no one expected. Bail revoked immediately, on the spot, not after a hearing, not after deliberation, not days later in a written order, right there, in real time, with the defendant being physically escorted out of the room. This was not courtroom drama. This was not grandstanding. This was a federal judge invoking the full weight of his authority in front of cameras, attorneys, reporters, and a packed gallery, and sending a message that is now echoing through federal courthouses across the country. When a judge with decades on the federal bench looks at armed marshals and says, "Remove him now," something catastrophic has just unfolded. And here's the thing most people do not realize yet. The removal was not the story. The bail denial was. Because when your freedom is revoked mid-hearing, while marshals are already flanking you, your entire legal strategy collapses in real time. This was not spontaneous, this was not emotional, this was calculated, and legal experts are now calling it one of the most decisive displays of judicial authority in recent federal history. So what exactly triggered this moment? Let's walk through it, second by second. The hearing began at 10:17 a.m. On paper, it was procedural, a pretrial appearance meant to address compliance issues and a pending government motion regarding pretrial release conditions. Nothing dramatic, nothing headline-worthy. But from the moment the defendant entered the courtroom, observers say the tone felt off. Multiple witnesses described visible contempt. The defendant refused to acknowledge the judge when his name was called. He whispered loudly to his legal team while procedural statements were being read. At one point, several people in the gallery reported that he appeared to laugh, not nervously, not under his breath, openly. Judge Caldwell noticed. He always does. For decades, Caldwell has been known for something rare on the federal bench: restraint. He allows defendants latitude. He tolerates frustration. He gives warnings where other judges would already be issuing contempt findings. But he also keeps meticulous records. And he does not bluff. After handling preliminary matters, Judge Caldwell turned to the issue at the center of the hearing: the defendant's compliance with pretrial conditions. That's when everything detonated. Mid-sentence, without being recognized, the defendant interrupted. Not a clarification, not an objection, a declaration. According to multiple reporters in the room, the defendant said, "This court has no authority over me. I do not recognize this proceeding." The courtroom went silent. Not tense silence, stunned silence. Judge Caldwell stopped speaking. He looked directly at the defendant, and for a moment, just one, he gave him an out. Calmly, evenly, he said, "You will conduct yourself with respect for this court, or there will be immediate consequences." That was the warning. The only one. The defendant did not apologize. He did not stop. He did not back down. Instead, he turned toward the gallery and made a dismissive gesture toward the bench. That was the line. Witnesses say Judge Caldwell's demeanor shifted instantly. Not louder, not angrier. Colder, measured, final. "Marshals," he said, "remove this individual from my courtroom immediately. We are done." 2 U.S. Marshals positioned near the side entrance moved without delay. This was not improvised. This was not reactive. They were already in place. The defendant barely had time to stand before he was being physically escorted toward the holding area. And then Judge Caldwell did something no one expected. As the marshals moved in, he continued speaking. "Let the record reflect that the defendant has demonstrated willful contempt for this court's authority." He paused, then delivered the bombshell. "Based on this conduct, combined with documented violations of pretrial release conditions, the court is revoking bail effective immediately." Just like that. Freedom gone. No sidebar, no recess, no debate. Legal analysts reviewing the transcript later were unanimous on one point. This was not impulsive. It was prepared. Within an hour, Judge Caldwell's written bail revocation order hit the court docket. 11 pages. Precise, clinical, devastating. This was not about a single moment of defiance in the courtroom. The judge did not simply react to a sharp word or a gesture. The order was rooted in weeks, months of documented behavior that prosecutors meticulously compiled. Missed check-ins with pretrial services, alleged attempts to contact witnesses despite a strict no-contact order, social media activity that prosecutors argued constituted intimidation. Every line in the order referenced specifics, dates, times, evidence. Each infraction built a pattern. It was not chaos. It was methodical. According to court records, the defendant missed 3 scheduled check-ins in the previous month alone. Pretrial services filed 2 formal notices of non-compliance. Both had been addressed in prior hearings. Both had been met with warnings. Warnings that expired the very moment the outburst occurred. The judge did not mince words. The order included language rarely, if ever, seen in federal bail revocations. The defendant has demonstrated a fundamental unwillingness to comply with the conditions of release and has shown contempt for the judicial process itself. Continued liberty poses an unacceptable risk to the integrity of these proceedings. That sentence is now circulating in law schools, dissected and debated, a textbook example of judicial authority asserting itself in the face of repeated defiance. And the order did not stop at words. It listed every documented violation, every text, every missed appointment, every potential witness contact. Each incident added weight, each added risk. By the time the document was filed, it painted a picture of a defendant whose behavior was no longer just reckless. It was dangerous to the judicial process itself. The bail revocation was not symbolic. It was structural. It was not meant to punish a single outburst. It was designed to assert control, restore order, and prevent interference. The judge, in effect, was drawing a line in the sand. Compliance is mandatory. Liberty is conditional. Court watchers note the order's surgical precision. Every paragraph ties back to federal rules. Every citation reinforced the reasoning. This was not a broad, vague assertion of authority. It was airtight, procedural, inescapable. And then there's the psychological weight. For the defendant, this order is more than a piece of paper. It is a statement that repeated behavior, even behavior outside of the courtroom, has consequences. It signals that the system is not reactive, it is proactive. It is anticipating potential disruption and neutralizing it before it happens. The implications extend far beyond bail. Lawyers are poring over each paragraph. Analysts are predicting how this could influence future proceedings. Precedent is being written in real time. And the message to anyone monitoring the case is unmistakable. The judicial system is watching closely, documenting meticulously, and willing to act decisively. By the time the order was filed, it was clear this was never just about an outburst. It was about establishing boundaries. It was about safeguarding the integrity of the courts. And it was about sending a message that defiance, no matter how public or personal, will meet a response that is methodical, relentless, and unyielding. The courtroom spectacle was only the surface. The real force was in the weeks of documentation, the procedural rigor, and the legal foresight embedded in every line of that 11-page order. This was not drama, it was enforcement. And for those watching closely, the stakes had just risen to an entirely new level. According to sources familiar with the case, investigators had been building a bail revocation record for weeks. Despite being ordered to limit public commentary about the case, the defendant continued posting, not directly threatening, not explicit, but calculated. One post referenced individuals believed to be cooperating witnesses, using initials, paired with language prosecutors described as thinly veiled intimidation. Judge Caldwell addressed this directly in his order. The defendant's public communications demonstrate not merely poor judgment, but a calculated effort to undermine the administration of justice. Former federal prosecutor Marcus Webb reviewed the filings and said something telling. This did not come together overnight. The judge had the record. He was waiting for the last justification. In other words, the outburst was not the cause. It was the trigger. Here's what most people do not understand. That hearing was not spontaneous. It was scheduled specifically to address the government's motion for bail revocation. Judge Caldwell had already reviewed the evidence. He had already consulted court security. The marshals were already positioned. This courtroom was prepared for escalation. What the defendant, and apparently his legal team, failed to grasp is that federal judges do not walk into hearings blind. They plan contingencies. And when the defendant interrupted the court, he was not testing patience. He was activating a response already locked and loaded. Even as marshals closed in, witnesses say the defendant continued speaking. "You cannot silence me. Everyone watching knows what this is," Judge Caldwell responded instantly. Let the transcript reflect that the defendant continues to disrupt these proceedings even as he is being lawfully removed. This conduct will be incorporated into sentencing considerations should there be a conviction. That sentence landed like a guillotine. The courtroom went completely still. One reporter described the atmosphere as electric, shock mixed with relief. A courtroom sketch artist with more than 2 decades of federal experience said afterward, "I've never seen anything like it." The judge never raised his voice, but the authority was absolute. As the defendant was escorted through the side door, he attempted to turn back toward the gallery. Marshals redirected him. The door closed. Judge Caldwell looked at the remaining attorneys and said, "We will take a 15-minute recess. When we resume, we will proceed with the government's remaining motions." And just like that, it was over. Or so it seemed. Federal judges have removed disruptive defendants before. But this was different. Historically, removal and bail revocation are separate proceedings. Consider the Chicago 7 trial in 1969. Judge Julius Hoffman ordered Bobby Seale bound and gagged, a decision later criticized and partially overturned. Or tax protester Irwin Schiff, removed from multiple courtrooms over decades. Even he was not held without bail for courtroom conduct alone. Judge Caldwell did something else entirely. He collapsed both actions into one ruling: removal, revocation, immediate detention. Professor Sarah Chen, a criminal procedure scholar, explained it bluntly. Judges usually remove first, then address bail later. Judge Caldwell combined them because he had the documentation. That documentation is what makes this bulletproof. Judge Caldwell's written order did not read like it was drafted in a rush. Far from it. According to a retired appellate judge who reviewed the document, that order was ready. He was prepared. Every violation was cataloged, every warning quoted, every missed check-in time-stamped down to the minute. This is how experienced federal judges operate. They do not react impulsively. They build records. Detailed, unassailable, airtight records. Records that can withstand scrutiny not just in the courtroom, but in appellate courts years later. Former federal prosecutor Marcus Webb explained it bluntly. Executing removal and bail revocation in real time requires supreme confidence. You do not do that unless you know your record will survive appeal. And that is precisely what makes this situation so daunting for the defense. The defendant is now being held without bail pending trial, a status in federal court that is notoriously difficult to reverse. His attorneys have a narrow window to file an emergency appeal. A small crack in procedure is all they have to work with. But here's the catch. Appellate judges will see the record. They'll see the transcript of courtroom exchanges. They'll see every formal warning issued in advance. They'll see the pattern of behavior, documented meticulously over weeks. And they'll see a defendant who, in attempting to challenge authority, effectively argued himself into a jail cell. Every procedural misstep now compounds. Every missed check-in, every social media post, every whisper of contact with prohibited parties becomes evidence of contempt. It's a chain, and each link strengthens the case for continued detention. This is not conjecture. It is precedent. Federal courts are clear. A judge who demonstrates a methodical approach, cites documented violations, and follows statutory procedure rarely has their decision overturned on appeal. The appellate path is narrow. The emergency motions filed by defense attorneys will be read with a critical eye. The question before the appellate panel is not sympathy. It is law. And the law in this case is unambiguous. Precedent favors the judge who builds a careful, detailed record. Precedent favors the system that acts decisively to protect its own integrity. And precedent, in cases like this, leaves little room for argument. The consequences are immediate. The defendant's liberty is constrained. His freedom is no longer a matter of personal influence or public attention. It is dictated by documented behavior, by the procedural rigor of a judge who anticipated every counter-argument. The courtroom transcript reads like a blueprint of compliance and violation. Every warning, every directive, every documented infraction becomes a brick in the legal wall that now surrounds him. Even his closest allies understand the challenge. They can issue statements, they can rally public support, they can try to frame narrative battles in the media, but none of that erases the record. None of it alters the fact that every warning, every misstep, every missed check-in is preserved in writing. Appeal is theoretically possible, but in practical terms, it's nearly impossible. The law is procedural, deliberate, and unforgiving, and Judge Caldwell built a record that almost guarantees the status quo will hold. The irony is unmistakable. A defendant who often portrayed strength, control, and influence is now at the mercy of documented facts. His courtroom bravado, his defiance, and his missteps have created a self-reinforcing trap. Every action that seemed bold in the moment now becomes evidence of non-compliance. Every interruption, every gesture, every word in open court strengthens the justification for detention. In short, the record speaks louder than any press release, louder than any statement from allies, louder than any social media post. It is precise, it is clinical, it is unassailable, and it makes appeal, in all but the most extraordinary circumstances, a near impossible endeavor. The courtroom shockwave is already spreading. Across the country, defense attorneys are scrambling, reassessing strategy, revising instructions to clients. The message is clear. Federal court is not a stage. It is not a platform for theatrics. It is a place of law. Judges have authority, and they will use it. Every legal scholar, every former prosecutor, every seasoned practitioner is watching this case closely. They are calling it a watershed moment, not because Judge Caldwell overreached, but because he didn't. He exercised restraint. He waited, he warned, he documented. And when the line was crossed, when behavior moved from defiance into outright contempt, he ended it decisively. The order itself is surgical, precise, clinical. Every misstep cataloged, every warning recorded, every timestamp noted. It's not arbitrary. It's systematic, and it sends a message that ripples far beyond one courtroom. Zealous advocacy has its limits. There is a point where defiance ceases to be strategy and becomes self-destruction. A former public defender put it bluntly, there's zealous advocacy and there's self-destruction. This was self-destruction. Every attorney in that room knows what this means. Every marshal, every clerk, every observer understands the stakes. When the defendant's lawyer reportedly looked physically ill as the marshals moved in, it was not surprise. It was recognition. Recognition that the moment marks an irreversible shift. The game has changed. Liberty can no longer be taken for granted. Every miscalculation now carries immediate consequence. Every misstep, missed check-in, forbidden contact, social media post becomes enforceable evidence. The system, long criticized as slow and bureaucratic, has demonstrated its capacity for precision and speed. It can wait, it can observe, and it can strike, all at once. The impact is already cascading. Defense teams nationwide are advising clients, do not test the limits. Do not assume charisma or influence will override procedure. Do not assume theatrics will sway a judge who has meticulously documented every infraction. Federal judges take notes. They track behavior, they anticipate appeals, and they build records that survive scrutiny. This is not just a lesson for one defendant. It is a signal for anyone who underestimates the procedural rigor of federal courts. The consequences extend beyond strategy. They are cultural. They are psychological. They redefine the boundaries between advocacy and recklessness. And the ripple does not stop in the courtroom. It reaches law schools, where professors are already dissecting the order. It reaches chambers, where clerks and judges quietly take note. It reaches attorneys in private offices, who now must measure risk with unprecedented care. For the defendant in question, the moment is decisive. The legal landscape has shifted beneath him. The balance of power, once partially in his hands, is now dictated by procedure, by record, by law. Game over. Not because the judge relished punishment, not because the system is vengeful, But because the law is exacting, it watches, it waits, and when the line is crossed, it acts, with clarity, with precision, and without mercy. This is the new reality. Every move from here on will be scrutinized, every decision weighed, every counsel warned. Because in federal court, authority is real. Compliance is not optional, and the consequences for ignoring it are immediate, irrevocable, and total. Game over. The lesson is unmistakable. The system works, and no one, no matter how powerful, is above it. This was not about ego. It was not about control. It was about preserving the integrity of the court. And Judge Caldwell made one thing unmistakably clear. Defy the system long enough, and eventually the system answers back, loudly, decisively, and without warning. https://docs.google.com document D 1 mkydapudgujzljbgdld 4wqzlndrndntxomg5a 5xf6wlk edit.usp sharing.